The chair lays out House Bill 2952 and the substitute and recognizes Chair Nayave to explain the bill.
Thank you, Madam Chair, members, and for the opportunity to hear House Bill 2952 and the committee substitute, which addresses the way that child support is calculated in Texas. Senator West in our office worked with the Attorney General's office on this legislation, and the reason that we need this legislation is because Texas is at risk of potentially losing compliance with federal requirements. So this legislation addresses a lot of the issues that the federal government has asked Texas to comply with. Passing this legislation will protect our federal funding for child support programs. It will provide necessary updates to the current statute. And I'll take you through each of the different sections of the bill and explain. We also have the Attorney General's office here who, as a resource witness, who can address some of the questions as well. But first, what I'll do is, and I will clarify, the committee substitute removes Section 12 of the bill, of the original bill, which would have removed a part of the statute that prohibits the use of digitized signatures on waivers. So that is taken out. So with that, I'll just briefly touch on Title 4D courts, what they do, and then next I will discuss what the legislation does. So, yes.
Did you lay out the committee sub? Or,
Yes, I
Madam
did
Chair,
say
you did. Okay, I missed it. I'm sorry. Thank you.
Thank you, Mr. Chair. Just brief background, the Social Security Act of 1975 contains Title 4D. We hear about Title 4D courts, which are our child support courts. A few years back in 2017, the Federal Office of Child Support Enforcement implemented a new set of federal regulations, and we're happy to provide you a copy of the specific regulations which address the bill that I have laid out before you. Those regulations are entitled Final Rule, Flexibility, Efficiency, and Modernization in Child Support Enforcement Programs. Texas has until January 1st of 2023, which is right before the next session, to implement the changes to our laws before we get any financial penalties imposed on our Title 4D programs, federal funding for the state. Currently, there's federal funding of Texas child support program totals $241 million annually and $482.1 million for the biennium. So the changes in this bill will address what's needed. One of the federal requirements to calculate child support requires, and I'll just quote, to take into consideration the basic subsistence needs of the non-custodial parent who has a limited ability to pay by incorporating a low-income adjustment, such as a self-support reserve or another method determined by the state. So I'm going to take you through those sections. And so I'd like to start with, first, the bill cleans up statutory language. I've already covered it. Okay. Let's start with Section 2. So Section 2 addresses the imputation of income. It states essentially that the court has to rely on evidence of a party's resources, but when there is no evidence, it delineates several factors that the court shall consider if there is no evidence of resources. So some of those potential evidence includes assets or residence, employment, earnings history, job opportunities in the obligor's community, the prevailing wage in that community, and whether there are other employers who are willing to hire that obligor. The next section states that a court cannot consider incarceration as intentional unemployment or underemployment. The fourth section addresses this change in the child support guidelines. First, the subsection A addresses, typically we see in the statute and the legislature changes it every so often to discuss the max amount of resources that would be considered. The statute currently has 7,500. What we're doing is changing the language so that it refers to what's been most recently published by the Title 4D agency in the Texas Register. So the goal with that is to help streamline having to change the statute every time. The second subsection B of that section addresses, these are the normal child support guidelines that we know. There's a change in the language there to account for this new low-income section that we have. And so I'll get to that section right now, and that's subsection C. So in this instance, if an obligor's net resources, and I'm happy to clarify what all of that means, but if an obligor's monthly net resources, which means after taxes, that's the number that the courts consider whenever they're considering child support. If that is under $1,000, then the court is going to use this chart that's here, the percentage to calculate the child support. Normally, if there's one child with no other children before the court, it's 20% of the obligor's monthly net resources. Here, in the instance where there's if the obligor, which is the person who has to pay child support, if they're under 1,000, it's 15%, and then there's a 5% increase thereafter. So this specifically goes to the requirements of what the federal government is needing from Texas. So that's that section. The other sections that it has on page 5, for example. Under normal child support calculations, if you have one child before the court, and let's say you have another child with another parent, for example, that's not before the court, the child support is reduced. So, and again, I'm happy to give examples, but normal 20% would be 17.5. There is now a chart specifically for the low income adjustment when there are other children that are not before the court. And so that 17.5% would be, in this instance, 13.5%. Section 6 states that incarceration of a child support obligor, if somebody has been incarcerated more than 180 days, that does not constitute a material and substantial change, which is what the courts look at whenever they're going to change child support. Section 7 says that the court essentially retains jurisdiction. It's adding language in there that we see in the family orders about medical support and dental support, which is new language that we have to have in the final orders. So this is just adding that on to the section to make sure that it's clear that the court retains jurisdiction. Section 8 deals with motions for enforcement of child support, just clearing up and making clear that cumulative. When there's a motion for enforcement of child support that requests money judgment for arrearages, it states what the judgments must have. So the cumulative money judgment, again, it clarifies there the medical support and the dental support to make it clear. And that's the same thing on page 7 of the bill of the committee substitute. Those are the main substantive changes. I'm happy to answer questions, and I'd respectfully ask for the committee's favorable consideration. Again, we have the Attorney General's office who can help clarify the necessity in the federal regulations if the committee has any questions. I respectfully reserve my right to close.
Members, are there any questions? All right, seeing if none, then the chair calls. And let me go ahead and mention the ones that are coming up so they can come in from the other room. Joel Rogers, and then Taryn Champagne, and then Celia Wood. Is Joel Rogers available?